my name is Miles Schneider, and you found my video probably because you want to know what the penalties are for being charged with a felony. So there are several different categories of felony sentencing in the state of Arizona. Non-dangerous offenses, non-dangerous repetitive offenses, dangerous offenses, dangerous repetitive offenses, dangerous crimes against children, serious violent or aggravated offenses, and offenses committed while released from confinement. So my guess is that you or somebody you know has been arrested, or you received a complaint in the mail, or an indictment, and that complaint or indictment lists the charges that you have received as felony charges. Well, you could always look at the Arizona Criminal Code sentencing charge that may be found on the Arizona Judicial Branch's website. However, without legal counsel, those charges can be confusing. Let me show you. Okay, so the first grid we're going to talk about is the sentencing guidelines for non-dangerous offenses. The left column lists the class of felony, and across the top, the row across the top to the right of that lists mitigated sentences, minimum sentences, presumptive sentences, maximum sentences, and aggravated sentences. The presumptive sentence is usually the sentence that you'll get if there are no mitigating or aggravating circumstances. If the judge decides you're sentencing down the middle, doesn't think you did anything especially heinous, or you aren't especially remorseful about your crime, you'll probably get a presumptive sentence. However, to get a mitigated sentence, if you take responsibility, if you're remorseful, if you pay restitution, if you have some people that will speak on your behalf about your character, a judge may offer you a mitigated or minimum sentence. As for an aggravated sentence, you get an aggravated sentence if the crime that you committed is especially heinous, cruel, or depraved, if the victim died or suffered physical, emotional, financial harm as a result of the crime. There are many aggravated circumstances that can come into play. The reason why we see blue over this felony sentencing guideline grid is because for first-time offenders, you're typically probation eligible, which means that you'll receive probation instead of prison time, but you'll still have that time hanging over your head if you commit another crime or violate probation, and the judge can impose the sentence on you. For example, if he says, okay, you're on probation for 2 years, just don't commit any more crimes, and you go ahead and commit another crime, the judge can impose that presumptive sentence that he initially set for you on the day of sentencing. I know this is a lot to absorb. It can be very confusing. These sentencing guidelines are in years, so there's a lot of time that can be hanging over your head. Please call me now if you have any questions. My phone number is listed below. It's 602-926-7373. I'll be happy to talk to you about your case. Okay, so let's talk about repetitive offenses in the same category, non-dangerous offenses. This category shows the possible outcome for having repetitive offenses. As you can see in your class of felony on the left column again, then you have your mitigated minimum, your presumptive, your max, and your aggravated in under category 1. Those are the same sentences as non-dangerous offenses that aren't repetitive. Then you have a category 2, which you can see is an increase in years for having second repetitive offense, and category 3, even more time. What you don't see is the blue shaded area for the presumption that you will receive probation. This is because if you commit repetitive offenses or several offenses that are being tried in one court case, the presumption that you'll receive probation is off the table. It doesn't mean that it's impossible to get through negotiation with the prosecutor. It just means that the judge doesn't have to give it to you, and that's what a presumption means. So as you can see, and it makes sense, that when you commit more offenses or repetitive offenses, the level of sentencing increases. Again, there are a lot of factors that go into each and every case and that are taken into consideration when we're talking about multiple offenses and felony charges. So again, if you're confused or if you need help figuring out the sentencing guidelines, please give me a ring. Okay, so let's talk about dangerous offenses. Right off the bat, you can tell that even with the first offense, dangerous offenses carry a great deal more time than non-dangerous felony offenses. The presumptive for a first offense of a Class 6 felony and a dangerous offense is 2.2 years. The presumptive first offense of a non-dangerous felony of a Class 6 type was 1 year. As you can see also, each time that you're charged with a dangerous felony and you have historical priors, the time doubles from your first offense to a second offense with one historical prior, and then triples if you have 2 historical priors. This is when it gets very important to hire a lawyer to consult with them, not only in terms of figuring out what your sentencing is going to be, but whether or not you can fight the case. Because if you have a Class 2 felony with 2 historical priors, you can spend half your life in prison. Again, if there's a specific charge you want to talk about, especially in the dangerous offense category, feel free to call me and we can talk about it. Okay, so now we're looking at dangerous offenses of a repetitive nature, which is just a little bit different than dangerous offenses having historical priors. These are offenses that apply to when you commit a dangerous offense of the same degree a second or third time. And then, as you can see, the increased maximum time is very similar to having historical priors as well as having repetitive offenses. Again, when we're looking at the possibility that you're going to spend half your life in prison, it's imperative that you consult with any lawyer or some lawyer to try to figure out, whether or not you should fight the case or take the deal that the prosecutor is offering. Okay, now we're looking at dangerous crimes against children. As you can see, these sentencing guidelines are very severe. There's only a small window of opportunity to be probation eligible when crimes are committed against children. You can receive an incredible amount of time offense, and a subsection A offense, and to receive up to life in prison for dangerous crimes against children. This is a very difficult category, a very complex category, and the sentencing ranges are very intricate, and you must seek out legal representation if you've been charged with a dangerous crime against a child. I'm just showing this guideline just so you know how serious it is. And every case is absolutely different, and every case is very intricate. So if you've been charged with a dangerous crime against children, please call a lawyer right away. Okay, finally, Arizona is known as a three-strike state. We have a three-strike rule, which means that serious, violent, or aggravated offenses of a felony nature can wind you up in prison for life. This provision was enacted in 2006, and it was enacted to make sure that the state keeps repeat offenders of serious, violent, or aggravated nature behind bars for life. And again, these are one of those categories that absolutely require that you consult with an attorney to talk about what the possible outcomes of your case are. So you can call me, or if you can't afford a lawyer, you can talk with a public defender. A crime of any felony requires that the state provide you with legal counsel to defend yourself, and you should absolutely do it as soon as you possibly can. You should always call a lawyer first before talking to the police about anything. Not only do you have the right to remain silent or the right to counsel, but you should exercise those rights so that you don't talk yourself into more trouble than you're already in. I know that was a lot of information to absorb. That's why it's especially important to consult an attorney about the charges against you, about the facts underlying the charges, and then the possible outcome with respect to sentencing. Again, you could always call me for a free consultation, and we can consult over the phone, or you can come into the office and show me everything that you have, your complaint, and any other evidence you want me to review, and I can give you, a good idea of what, the possibilities are in your case and how we can best defend you. Again, my name is Miles Schneider. My phone number is 602-926-7373. Thank you.